And good evening from outside of the Chambers County Courthouse. Thanks for joining us here on YouTube Live. We just finished day 7 of Sarah Hartsfield's insulin murder trial. There has been so much testimony. My notes are up to about 80 pages or so long now. We have heard from dozens of witnesses that the state has called, and it appears that the state may be close to resting their case, possibly with their last witness on the stand, the lead detective who investigated this case back in January of 2023. And we heard so much testimony from her today. In fact, she was on the stand for almost the entire day. She took up the entire day, and the defense didn't get to questioning her until toward the end of the day. And we are expecting to hear more from that lead detective first thing tomorrow morning. But I want to bring in our legal expert, Rick DeToto. He is back with us tonight in the studio from Houston. Rick, good to see you again. Welcome back. And thank you for joining us again.
Good to be back. Thank you.
So I want to start with really the big stuff that we heard today that I think is really, we've talked about this actually. We talked about it last week about the phone records and what they may have been able to find in Sarah Hartsfield's phone during this murder investigation. So just to kind of recap and give everyone a sense of the things that we heard. So when Sarah Hartsfield was at the hospital during a second interview with the detective told her that she wanted to get her phone. And Sarah Hartsfield responded to that detective and said, "Oh, crap. So here's the question. Do I have to give this to you without a warrant?" At that point, the detective actually had a warrant. And so Sarah Hartsfield had to hand that phone over. And then they did what's called a phone dump. And Rick, just so everyone's aware, what is the phone dump? What happens with that?
So basically, they go through every single bit of data on your phone. That's text messages, web scrolling, apps, anything. And sometimes these phone dumps can be up to 90 to 100,000 pages of material. So it's every possible data point and piece of data on your phone, your text messages that can read them, your calls, everything you can think of that would be on your phone.
So in this case, they got a lot. And this is a defendant who we know likes to write and has a lot of things on her phone that they started looking at. So some of the key pieces of evidence that the detective said that they found from her phone. First of all, during the time that Joseph Hartsfield was laying unresponsive or with a critically low blood sugar level, that was for about 20 hours, according to the medical testimony and according to what we saw from the data from his glucose monitor. But during that time, Sarah Hartsfield had claimed that she was asleep, in and out of sleep, and on narcotic pain medication, basically not able to help him in any way because she said she was recovering from her own surgery. But what we heard today from the detective is that they actually found there was a lot of activity on her phone during several hours leading up to when she says she initially woke up. So she said that she woke up around 1 o'clock, and that's when she found that Joe was having some complications. But actually, the detective said that activity on her phone started around 4 o'clock that morning. I should note 1 in the afternoon. So the detective said that basically every hour of the day, she was doing something on her phone, including they used Apple Movement. So, if you wear a watch or if you have, your activity tracker on your phone, it's keeping track of your steps. Have you ever heard of that being looked at in a murder case like this?
Yeah, I've actually encountered that in one of my murder cases, and the prosecution had a very detailed analysis of the movement of the phone, when the phone was on, when the phone was off, when the light was on, when the light was off. So I think the people in the community and the public need to understand that all this stuff can be tracked by your phone, and they can determine kind of where you are, how many steps you've taken, were you using your phone, what were you using it for. So I think that kind of ties in when she said, "Oh crap, do you have a warrant?" She may have been concerned what they were going to find and what they showed in court today.
So they got the phone, the movement, if you will, from her phone app. And so again, there was several steps that were taken again each hour of the day. But then between 1 and 2 p.m., which according to Sarah was when she was awake and actually trying to help her husband, during that hour from 1 to 2 before she called for EMS, the detective said that was the only hour actually where there was no movement on the phone. There were no steps that were taken during that time. So that was one piece of just interesting testimony and evidence that we had not yet heard. We also heard that there were possibly 100 glucose alarms that went off while Joseph Hartsfield's blood sugar level was dangerously low. And one thing, Rick, that came up that really I think was a shock for a lot of people in the courtroom was this thing called Apple Legacy Contact. Have you heard of that, by the way?
I actually did not hear about it until me and you talked about it earlier today, and it's very interesting that someone in that position allegedly is looking at that Apple legacy website to try to transfer some of the information. It's difficult evidence to potentially overcome as the defense lawyers.
Yeah, this is interesting. I had never heard of this Apple legacy contact until today either. But basically, if you use an Apple device, it turns out that you can basically set it up so that all of your data will be transferred over to someone when you die. And so, again, Sarah Hartsfield called for EMS at 2:02 p.m. on January 7th, 2023. But around 5 o'clock that morning, during the 5 o'clock hour, the detective said there was actually a message sent from Joseph Hartsfield's phone to Sarah Hartsfield's phone, and then saved, like a photo saved to her phone, again, all within the same minute in the 5 a.m. hour. And it was that Apple legacy contact. And basically, it was setting up all of Joseph's Apple phone data to be transferred over to Sarah once she provided a death certificate. Again, this is 5 o'clock in the morning. He was not dead. And it was 9 hours later or so when she called for EMS. So it raises a lot of questions. I mean, how do you explain that?
Well, I think today obviously was a very difficult day for the defense, and I'm not sure they're going to be able to explain that away. If I'm the prosecutor in this case, I'm arguing that this evidence is inconsistent with what she told the police. It kind of shows that she was anticipating his death. Maybe she was potentially hoping for him to die, and that ties into the Apple legacy information. But obviously a very difficult day for the defense. But we have to come back and get back to the murder accusations. Can they prove that it was murder? Did she intentionally do anything to cause his death, i.e. potentially putting extra insulin in his body? And I still think that's going to be the argument there. While it's a very tough day for their defense, they still have that argument, and they have to decide how they want to go to the jury charge, and we'll talk about that in a couple minutes.
Yeah, we got to talk more about that because that did start to come up today. But I'm really hooked on these phone records because I feel like I couldn't type fast enough to take down all of the notes of the things that we were learning about when it came to what else they found on the phone records. So, again, during this time when she was saying that she was possibly, sleeping and on this narcotic pain medication recovering from her surgery, there were also a lot of Facebook messages that it appears that she was sending. And one thing that just kind of stuck out to me, she was messaging with a friend who doesn't appear to live in town, and she was talking to this other woman just about kind of some concerns that she had about Joseph Hartsfield and the way that he managed his diet and the way that he managed his diabetes. And then at 2 o'clock, 2 minutes before she made that call to 911, she actually told this friend, I'm going to call 911. She told the friend that she was going to do that. Again, this was during the hour, again, from 1 to 2, when she might have been up and walking around and trying to clean up the vomit that she said she found and trying to, get his sugar level to go back up by giving him, glasses of juice and the jelly that she said that she might have tried to put in his mouth. So if you're messaging a friend at 2 o'clock on Facebook and the phone dump shows that, then 2 minutes later you call 911. I mean, the question from the prosecutor was, like, where were your priorities? Or how does that kind of show what the priority was in that moment? Like, how do you kind of explain that?
So the prosecutor is obviously going to argue what you just said. You made the perfect closing argument for the state that she was more concerned with maybe setting up her defense or, talking to people about what was going on. But the defense is going to argue, and we argue in these type of cases, you never know how you're going to react in these type of situations. Number one, was she really under the influence of some type of narcotics based on the surgery she had? Was she loopy? Was she scared? Was she confused? Was she reaching out for help? You just don't know how people are going to react in that situation. We as a public tend to project our feelings on exactly how we're going to react in these type of situations, but you just don't know. It's a difficult argument for the defense, and I understand both sides, and that's why the jury has to decide what they believe.
It seemed like the jury was really tuned in for that. I've seen they all are carrying notepads, and it appears that they're really taking notes on the things that they're hearing because this is day 7. I mean, they've heard a lot at this point. That we were off, obviously, for the weekend. I assume they're getting tired and also trying to keep everything straight at this point also. So having those notes is helpful. Early today, Rick, the text messages that Sarah has sent from jail to various media outlets, including to me, since she has been in jail, those came up. And what ended up happening with them is that they redacted certain parts of them for some of the things from the past that they did not want, that the judge basically was not going to allow in. So they redacted any mentions of things from the past that weren't allowed in so that they wouldn't be in those files. But then they did get admitted. It's not like they went through each and every line to talk about the inconsistencies in the story, and they're admitted. So now does that mean the jury can look at those messages with the media that Sarah has sent, like if they want to, while they're deliberating?
Yeah, absolutely. So as lawyers, as these long trials go on, we have to be aware of the jury getting tired, like you talked about, and we don't want to go through 4 or 5 hours of text messages that annoys the jury and starts them, they start not liking you because you're wasting your time. So you have to kind of pick and choose the best text messages that prove your case, then you introduce the rest, and then in closing argument, you can go on and argue some more of them, and you ask the jury, hey, when you go back there's these text messages you need to look at, they're on this page, we didn't want to waste your time in court, but they're in evidence, please go back there and look at them and see how they help you to decide this case.
Well, one key thing is again, the messages that she has sent to me from jail. One of them that I actually wanted to show everyone was talking about those Dexcom alerts. Like I said, the detective mentioned that there were about 100 alerts that they knew of that went off on his phone that were also shared with her. And those alerts, apparently, the settings that he had, they couldn't have been silenced. She said she didn't ignore his Dexcom alerts, that she was on her own pain regimen in another room after having another surgery, and that Joe knew she couldn't do anything for him because she was sleeping most of the day and night. Again, that is the message that she sent me, appears to be in conflict with what the detective says that she was doing on her phone during that time. I think actually the detective said like she was on the HEB app and ordered a grocery delivery. And then when they went into her house early around 4 a.m. on January 8th, all of the groceries that she had ordered were actually still just sitting on the kitchen table. They hadn't even been put away at that point. The prosecutor pointed out that the messages that she had sent me were actually in conflict with what she has told other media outlets, and I guess that was part of the reason that they wanted to admit those. Again, when we're talking about so many pages of this, do you think that's something the jury would actually even look at or care about at this point?
Well, it depends on the jury. I've had some juries that are very meticulous and they go through every single document, they take notes and they argue everything back there. But I think the most important thing that got across to the jury from the prosecutors today was over a 20-hour period, 100 alerts. If it's a couple hours and there's 5 or 10 alerts, you might be able to explain that away, but over 100 alerts over 20 hours while she's shopping, while she's looking on the internet, it appears that it's inconsistent with her story. It appears that she may have, the state can argue that she was awake, she knew what was going on, she was able to, shop on the internet, and she was able to pick out specific groceries that she wanted and have them delivered. So, again, that's tough information for the defense. They're going to have to figure out a way to argue their way out of it, but I think that's probably why the jury may have been super interested today in writing that stuff down, because today was probably the most damning day, again, as I said, for the defense.
Yeah, it's interesting you say that. I was kind of trying to find the word earlier to just kind of talk about the phone records, and of course we had talked about it before. It's like you never know what's going to be in there, and I guess some of those little things that may be hidden. I should also note that the detective said when she got the phone, it actually appeared that Sarah Hartsfield had deleted some of her messages, and so the detective was able to go in, I guess on iMessage and in messages go and see what the recently deleted things were, and so the detective was able to find those. And the detective also said that Sarah's phone history for internet searches had been deleted for the day of Joseph's hospitalization and the day before. So when you don't have that phone history, when you don't have that search history, and you can't say what she was searching, does that, I think, leave some questions for the jury, or how do you think that gets processed?
So the question that has to be asked is she routinely deleting her history on her phone? Does she do it, every week, every month? Mm-hmm. I do it every day or every other day. So if they go back on her phone and they see that it's never been deleted, or it's deleted occasionally with no specific period, but on these 2 specific days she deleted her history, they can argue that she's attempting to hide something. If I'm the prosecutor in this case, I would get a bag of groceries and I'd fill it up with groceries, and I would say, while this man was dying in his room, 100 alerts over 20 hours, she was shopping for a banana. She was shopping for Oreo cookies. She was shopping for bread. And I would bring that out to the jury, and it's something I think they'll remember and they will stick to. To me, it was kind of, wow, she's shopping for groceries while this is going on. So that's kind of how I think that I would argue that case in terms of a prosecution.
That's an interesting point. Like you said it before, this is kind of like theater, and I guess visuals help. I should also add one more thing about kind of some of the other things that apparently were sent from his phone to her phone. Apparently, it was a photo of his new bank account records, because he had just opened a new bank account back home, apparently in putting together his plan to leave her. He had opened a new account where his direct deposit was going to go. And then also apparently there was a photo of his driver's license that got sent from his phone to her phone, all during, that same 5 a.m. hour when we're talking about the legacy contact and everything. And based on the medical testimony, Rick, that we have heard here, it's that because his sugar was so low for so long, he likely, would not have been coherent enough to be actually the one doing those things on his phone. He would have needed help from someone to get his sugar to go back up. One other thing that we heard about in court today, we heard some of the jail calls that Sarah Hartsfield has made, and that was interesting because she placed several calls to her children, especially kind of throughout the time that she's been in jail for more than 2.5 years here. How often do you see the jail calls actually come up when it gets to time to be the trial?
So the first thing I'll tell you, that I've been a criminal defense lawyer almost 30 years now, and it still amazes me because I tell every single one of my clients that are in custody, do not talk about anything related to your case on the phone. They record it. Sometimes it can be sent to them live and they hear it and it's recorded, and it still happens. We still get cases all the time where clients are calling their mom or their sister or whoever, and they're saying things that hurt them. So it's pretty common in criminal cases. It happens a lot. I've dealt with murder cases. I've dealt with all kinds of cases where people are on the phone talking about things that they shouldn't be talking about. And it doesn't necessarily have to be a confession. It could be some information that leads the investigation somewhere else where they may not have known. So it's pretty common in criminal cases.
So the ones that we heard from her, actually, one of the calls was to her son. And she was telling him that he really didn't have to comply with any sort of subpoena to this trial. The way that she described it to him actually on the phone, she said, Ryan is his name. She said, Ryan, it's basically like sending out an invitation to a party, sending out a subpoena. You send out these invitations to the party and you can show up or you don't show up. But it's kind of, again, like an invitation where, maybe you send out 30 to a party and only 10 of the people show up. So without saying don't show up, son, it seemed like she was, just telling him, hey, it's like a party and you don't have to show up. I actually took down a couple of quotes that she said when she talked with her daughter in those jail calls. One of them, she said to her daughter, she said, I made bad choices, but that doesn't make me a murderer, and it certainly doesn't make me a criminal. In a different call, she said to her daughter, again on that recorded jail line, which there is a notice, by the way, you hear at the beginning of the recording where, hey, this call is being recorded. A different thing she said, you need, to her daughter, she said, you need to think carefully about what you're going to say. And then she said a couple of other things. She said, you still just keep kicking me in the face. She was, again, talking to her daughter about the possibility of having to come and testify and talk about Sarah at the trial. So the jury heard those. Any thoughts on kind of how those play? Obviously, it wasn't a confession or anything, but she appeared to be really kind of trying to influence them and what they may or may not say about her.
Yeah, so I think the state is probably going to make an argument that allegedly she was witness tampering. And witness tampering is basically contacting a witness and telling them, look, you don't have to show up. It's like a party invitation. You should RSVP to the party. Or if you show up, I'm going to kick your butt. Or if you show up, I'm going to blow up your car or anything like that. So I think it's prime argument for the prosecutors to say that she was attempting allegedly to manipulate the witnesses in this case to either come to her side or to not testify against her. And again, that looks really bad in terms of her defense in this case, because if she's innocent, she would not need to do stuff like that. And that's the argument the state's going to make.
By the way, is it like just an invite to a party? They kind of are more serious than that, right?
Well, it's a little bit complicated with subpoenas. If you're personally served, meaning a deputy comes to you and hands you the subpoena, if you don't show up to court, the judge can order a deputy to go get you and bring you back to court and hold you until you testify. If the subpoena is mailed to you, they can't prove service, so it's a little bit more of a gray area. But it's definitely not an invitation to a party. It's something that everyone should take very seriously. And you can either contact a lawyer or contact the person that subpoenaed you, because if you don't comply with the subpoena, there can be penalties that are criminal and or civil. So you definitely need to comply with it when you're subpoenaed.
Yeah, you're not just going to have like friends mad at you or something if you don't show up to the party.
No,
there
sir.
could be bigger consequences than that. I mentioned, like I said, the kids testifying. So all 4 of her children took the stand yesterday, and we didn't get a chance to really talk about and debrief that. But part of the reason that the kids were there and part of the reason that they testified was because they've been talking about some of these extraneous offenses, the alleged crimes that prosecutors say Sarah committed in the past that they've wanted to bring up. And I know initially you kind of expressed some concern about the jury getting to hear about some of these things from the past during this portion of the trial when we're talking about, the murder allegedly of Joseph Hartsfield. Now that you've seen some of the notes and see, just for anyone who didn't catch up yesterday, the things that we've heard about in terms of some of the extraneous offenses. We've heard about a murder for hire plot, allegedly, that was investigated by the FBI and directed by Sarah to have one of her ex-husband's new wives, the stepmother of her children, killed. That was amid an ongoing custody battle. We also heard about when she fatally shot a fiance in Minnesota. In that case, it was initially ruled self-defense. And Sarah's daughter testified that, her mom was mad at her, actually shook her in a back room and told her to go and, tell the police a different story. And then we also heard from some of her exes as well as her brother about when they believe Sarah set or tried to set fires inside of the homes where they were at the time. Again, this multi-state history that we're talking about here. The murder charge, obviously in Texas, one of those alleged arsons in Texas. A different arson allegedly involving her brother, that was in Missouri. And then there in Minnesota is where the shooting of David Bragg happened. Now that we have heard some of these things, the jury has heard some of these things, what's your take on the judge letting that information in here during this guilt-innocence phase of the trial?
I am still really surprised that some of the extraneous offenses have come in, specifically shaking your daughter and telling her not to tell the police. I'm not sure how that comes in under the statutes regarding extraneous offenses in this case. So potentially it could be setting up errors on appeal if she's convicted. Some of them I can see how they can fit into the exceptions under the Rule 404B of the criminal code. I guess my biggest thing is I would, as a defense lawyer, after the prosecution does direct examination, I would be asking these witnesses, did you speak to the police? Yes. Did you tell them the story? Yes. Did you give them the full story? Yes. Were you truthful with them? Yes. Did they tell you they were going to investigate these extraneous offenses? Yes. Did they investigate it? Yes. After they did all these investigations, she was never charged. So there's both sides of this. Clearly the prosecution is trying to show that it's not her first rodeo, and they're trying to make the jury not like her and show that potentially she's been doing this her whole career and it fits in with what happened here. So there's two sides to that, but I'm still really surprised that some of the extraneouses were let in by the court. In my opinion, they probably shouldn't have been let in front of the jury in guilt-innocence.
When you do like a quick Google search about these extraneous offenses in Texas, I think AI tells you it has maybe something to do with motive or intent. The exes that have testified have all said that actually even the kids, several people that have testified, when they're asked to describe, how their relationship was with Sarah, they have used the word tumultuous. And actually her third ex-husband, who she was married to the longest, he's the father of all 4 of the children. He said that, he was really not allowed to have a relationship with his family when he was married to Sarah. And that's kind of what we've heard about Joseph Hartsfield, that, she really was not happy about the relationship that he had with his family. They were a pretty close family. So when we're talking about these extraneous offenses and the AI description that you see about motive and intent, like how does that play in, or if at all? Like, does that have anything to do with letting the jury hear that now?
So first, I don't think a lot of that's relevant. Again, that's just my opinion, but the court has to do a balancing test. They have to determine if the introduction of the extraneous offense does not cause undue, unfair prejudice to the defendant. So I think there is cause for some of these extraneouses to come in, but I think the ones you just talked about are not relevant to this case in terms of guilt or innocence. And number 2, they cause extreme unfair prejudice to the defendant in terms of what the jury should hear. So again, that's just my opinion. But I would be, if I'm the defense lawyer in this case, I'm objecting like crazy. And if she's convicted, it's something that would become a point of appeal in this case to try to get a conviction reversed.
Rick, it's like you maybe talked to the defense attorney, because he did object a lot, and he did exactly what you said about asking, did you talk to the police about this? Did they investigate? Did, she ever get arrested? Did she ever get charged? And in all of the cases, of course, the answer was no. In fact, in one of the cases, I think from the 90s, one of those attempted alleged arsons, the testimony from the witness was that the police told them to get a big dog or something, and that attempted arson wasn't a charge that they could go for at that time. So, yeah. I mean, we're talking, years of where people say that they really haven't gotten the response from law enforcement when they've tried to report things, or, maybe Sarah has told them things they said, later, not in the middle of the investigation, but maybe she's told them about what went on with something years or months later, and then at that point, they've thought there's nothing really that they could do about it. Well, I want to ask you, because this has been part of the defense's argument so far, is about the errors that may have been made during this law enforcement investigation. So we've heard from several current and former members of the Chambers County Sheriff's Office, which of course is the law enforcement agency that investigated this murder. And when they first went to Sarah Hartsfield's house, again around 4 o'clock in the morning on January 8th, while Joseph Hartsfield was still in the hospital in a pretty bad condition, they went there. Sarah, I guess, gave them consent to go in and search the home, and they looked around, and her statement, her admission to them was that she had given him 2 insulin pens the night before. It wasn't clear if it was short or long-acting insulin. And also, she said that she gave, when she was there in the body camera video at the house, actually, she was handling the insulin pens. So law enforcement never collected those insulin pens. And the testimony from the detective today was that she doesn't really think that would have changed the outcome of this investigation and where she went with it, because, by Sarah's admission and by what you could see on the body camera, she had actually touched them. So they would, at that point, reasonably believe that her, DNA and fingerprints were there on those pens. So when we start talking about law enforcement mistakes in an investigation, especially one that's so high profile like this, how do you think that plays with the jury?
So as part of what we do as defense lawyers, we pick apart the investigation by the police department to determine what they did and what they didn't do. And they have very specific protocols in terms of what they collect at the scene, the crime scene investigation. But as soon as she told them that she handled those pens, the first thing that popped up in my mind is collect those pens and let's test them. Is her fingerprints on there? Is there contact DNA on there? But all the other ones on the bedside, same situation. Can we prove that she touched them? Is his DNA on the needle from sticking it into his arm? That's all stuff that we have to do to try to raise reasonable doubt in a case. Now, there's 2 schools of thought. One is that, yeah, it's just the defense lawyers going after the police to try to prove that the guilty client is innocent by attacking the police. Okay. The other school of thought is that there could be something very small in a case that can prove someone is not guilty or tend to show reasonable doubt in a case. And we expect and we hold the police and the crime scene investigators to a higher standard to make sure they investigate everything. When a police officer doesn't collect evidence and says, well, it doesn't matter, it wouldn't have affected the case, that's not a fair statement. And I don't think that's fair to the defendant in this case. I don't think that's fair to the public in terms of investigating a case. That's all they can say. They can't say, no, if we investigated it and we found something out, it would have changed the case. So I think it's a pretty big error. I applaud the deputy or the officer in the case who said we made an error, but it's hard to tell the effect that has on the jury. It has a lot to do with the other evidence in the case.
Yeah, that is kind of the testimony that the detective gave, was that there was so much else that they did get, and she said that the murder weapon was that insulin pen. Another piece of evidence that law enforcement didn't collect was anything from surveillance cameras. So the detective said that there were cameras inside and outside of the home, but when they asked Sarah about them, she said, oh no, actually those stopped working about a week ago. I had to take them offline because I was installing a new camera. And one just thing I want to add here was that there was kind of a contradictory statement to that then later, because Sarah actually sent a surveillance image of Joe from just one day before he was unresponsive. It was a surveillance video, image or video of him from outside where she was trying to say that he looked like he had like stroke symptoms. And she actually sent that surveillance image to the medical examiner who was working on the autopsy. So the detective said, hey, there's a contradiction here. If the cameras were offline, how did you have this photo from one day before when you said that they were actually offline, for a week or two leading up to all of this? So the detective then said that they didn't even try to like collect the receiver with that video. In a perfect world, would surveillance video like be the one key that's missing here, or do you think there's still more missing from what we've heard so far?
So in my opinion, in 2025, it's absolutely negligence for the police officers not to collect video surveillance evidence because it can show what really happened. But the most important thing from the police perspective and from the investigation perspective is they know that a defense lawyer is going to be questioning their activities, what they did and what they didn't do, and compare that to what the defendant says or doesn't say. So if you collect the video and you have it, you can cut that off. You cut off our arguments that you didn't collect the video, it could have showed that something happened, thus there's reasonable doubt. There's cameras everywhere. I see on KPRC Channel 2 in the news every day, you guys are telling stories about there's a surveillance camera of an evading arrest, of a burglary of a habitation. So in my mind, it's absolute negligence for them not to collect those videos to, at a minimum, cut off the defense arguments, but at the most important part, show that the person is or isn't guilty. So that's a really big mistake. It's impossible to explain why they didn't do it, but they just didn't do it in this case.
Yeah, you have to imagine what the conversations may have been like inside of the sheriff's office, or what they are now that this is coming up, and if anything has changed, just to ensure there's maybe a checklist or something that they get everything that they need. And I should add one thing here. The detective, Skylar Rocks, she's no longer with the Chambers County Sheriff's Office, but this was the first call out that she actually had as a detective. She had been a detective for, I think she said 6 weeks. And she got called there to the hospital when the staff suspected foul play and when the family was kind of casting some suspicion about Sarah's possible involvement. And so she said this was her first call out, but when they were at Sarah's house, she was not technically the one in charge because there was a lieutenant there, someone above her who was kind of the supervisor at the scene. And both of them really have said that they regret and take responsibility for not collecting that evidence that could have been really so crucial here. We talked about this a little bit as well when we're talking about kind of some of the true criminess aspect of this, seeing kind of these body camera videos from the interviews, talking about inside of Sarah Hartsfield's home, inside of the bedroom where you can see them photographing the actual insulin pens and prescription pill bottles all over the room. For a jury, and you see Sarah's demeanor too, by the way. At the hospital, there were some tears. And in the home, she was talking with them very calm, very level-headed. She was not too seemingly concerned. And she definitely didn't seem to be talking or worried or upset about her husband's condition, especially in the bedroom there with the detectives. When you see someone's demeanor and you see that body camera video, how does that kind of help the jury make up their minds? Which, by the way, it's 8 men and 4 women.
Yeah, it's very cliche, but a picture in our business, just like anything else, is worth 1,000 words. So you can have witnesses come up and testify to police officers about her demeanor and how she was behaving and what she did, but that video is direct, absolute proof that she did not appear to be emotional, did not appear to be crying, was calm, cool, and collected. So an argument can be made by the prosecution that, she's a murderer. She intended to do this, allegedly set this up. She's trying to get money from him. She's surfing on the internet when he's dying, and we talked about the groceries and all that. So that's the argument that I think the prosecutors will make, and that demeanor ties into their argument. But on the other side, and I always say this, you don't know how you're going to act in a situation like that. You just don't. You could be in shock. She still could be under pain medication. But it's compelling for the prosecution to make that argument, and then for the jury to also see it on that video.
Yeah, it's definitely been interesting, and obviously some of it's a little bit difficult to hear because she wasn't, standing right in front of the camera, but you could still kind of see and make out everything that was going on. And of course, we've shared kind of some of those clips on our YouTube channel if anyone hasn't seen them. Rick, I mentioned already kind of the objections that have come up. The defense has objected a lot. I think some of the main ones that we keep hearing include for hearsay and for confrontation. Is that kind of just part of the strategy to make sure that, everything is set straight in the record?
Well, it's strategy, but also as lawyers, there is a court reporter in the courtroom that is taking down every single thing we say. And if she is convicted, the Court of Appeals is going to see that record. So in order for us to preserve an error means we're objecting to a question that's asked or evidence that's admitted. We have to say it out loud. Objection, hearsay, objection, violation of the Confrontation Clause. We have to give a specific reason for the objection. If we don't do that, it's waived. So we have a duty to do that. And I explained to my juries in jury selection, look, I'm going to be standing up and I'm going to be making objections. Sometimes it's going to get annoying, but I have to do it. It's my job. It's what I have to do to protect my client and to protect the record. And when we say protect the record, to make sure that we're objecting clearly and specifically so that the Court of Appeals can see what we're objecting to.
Yeah, the judge even referenced at one point, he said, because the defense attorney, you saw there, Case Darwin, he has asked, for like running objections on certain things that he has brought up when certain witnesses have been on the stand. And the judge said, after he had done it over and over again, and you could see maybe some of that eye rolling or reacting from jurors or even the witness, I think, at a couple of points. When he asked for the running objection, the judge said, I know you're just trying to, protect the record here. When you hear, though, about especially some of the allegations that have come up and some of the things that have been allowed in at this trial, and then the objection is for hearsay, what do you make of that?
Well, he's objecting to some of the comments made by people that, out-of-court statements that were testified to people that aren't present in court, and again, he's just trying to protect the record. The Confrontation Clause issue, I would suspect, is that there's evidence coming in that the witnesses aren't there, so he cannot confront them. Mm-hmm. And under the United States Constitution, you have the right to confront your witnesses, meaning you have the right to cross-examine a witness that testifies against you. But we may have a third party that says something to the witness who's now testifying in court. That's hearsay, and it could be a violation of the Confrontation Clause. So that's what the defense lawyer is trying to do in terms of what we just talked about in making sure the record is clear in his defense.
Yeah. That makes sense. Thank you for explaining that, especially for people who haven't been in the court and been able to kind of hear what we've heard throughout every day. One thing I want to ask you, because this came up in, I think, the YouTube live chat questions. We talked about that Apple legacy contact where it was, about 9 hours before she called and she had appeared to set herself up as the person who would get all of his Apple data after he died by sending that to herself, according to the detective. Does that make it like premeditated, or does that change anything? I know that that's maybe a question that people might have when they're looking at this, just kind of as a general observer.
Yeah, so what people need to keep in mind is the allegation against this woman is murder, that she committed an intentional act that caused the murder of this person. So that may upset the jury and make her not like her and make her hate her and make them potentially allegedly believe that she was setting this up to get funds or whatever, but that does not necessarily mean it's murder. I understand what the state's doing. The jury may not like her, but then the argument has to be made, does she do an intentional act to cause the death of this individual? I still think it's a tough case to make. The jury could be so upset with her that they decide it is, but legally, in my opinion, I still think it's a difficult case to make without testing the insulin, without proving that she did anything except lay in her bed to cause this person's death in terms of intentionally committing a murder.
Okay, so then you bring up another point that I wanted to ask you, because the jury charge is something that came up today at the end of a court. And I should note on this that at the beginning of this investigation, it appears that law enforcement noted in their reports and even like on the title of some body camera videos that they were investigating attempted criminally negligent homicide. In fact, the search warrants that they initially got were specifically noting the offense of attempted criminally negligent homicide. Then the detective said throughout the course of the investigation, when they kind of determined that there was maybe some intent and knowledge that was behind it, then that's when apparently it changed to murder. So we've heard this mentioned. The defense has brought up this possible attempted criminally negligent homicide multiple times. Do you think that that is a charge that the jury could end up considering here in this case?
Yeah, so the defense attorney is going to have to make a decision if he wants to ask the court to allow lesser included. A lesser included is an offense that's included in the original charge, but is a less, it could be a lower felony, it could be a misdemeanor. So he's going to have to make a decision. It's a tough decision, and only he knows and has an opinion on whether or not it's all or nothing. Look, we don't ask for it. they can't make murder. They either have to make a decision on murder or not, or do we give the jury a potential out, but that potential out could be a lesser offense with a lot less jail time. Criminally negligent homicide is a state jail felony. The range of punishment is from 6 months to 2 years. Murder is 5 to 99 or life. So it may be something that they want to do strategically to try to get the jury to, at a minimum, convict her of that lesser offense.
And when we're talking about it being a state jail felony and you're talking 6 months to 2 years, I mean, she's already served 2.5 years. So at that point, it may not be serving any time at all, right? Because you would get credit usually for time served.
Yeah, so if she's convicted of that offense, you know, it's time served. I don't know what the policies within the county down there are, but state jail felonies are served day for day. But if she has over 2 years, it would be a time served situation. And I think, you know, potentially in this situation, the defense could call that a win.
Interesting. We'll have to see. I know the judge kind of directed the attorneys to get the jury charge figured out at the end of court today. He said he didn't want to keep the jury waiting for that whenever it does come time to do that. But we do know that obviously the defense has not even started to put on any of their case yet. They had some shared witnesses that the state had on their list that the defense subpoenaed, but it did look like from some of the subpoenas that we saw go out that the defense has subpoenaed some additional people to come testify, and we'll see, you know, how many of them are here in the coming days. We want to ask you one more thing, because I know we've talked about this as well before, Rick, about the possibility. Sorry, there's more bugs again. The possibility of Sarah testifying in this. So it seems like her reactions have been a little bit lesser. She doesn't appear to be like turning around as much. But I think there's video of her from today. If we have that video of her in court, and we can replay that while I'm talking with Rick about this. I think there was a moment where she kind of looks at her attorney, and I think it's right after this clip of Skylar Rocks on the stand. And she looks, there it is. You see it?
Yes, sir.
She kind of makes eyes at him, and she's saying something to him. She's been taking a lot of notes in this, and I'm just curious, based on, again, these past allegations that have come up, and all of the inconsistencies that the detective noted in her story, and all these things that the detective says the phone showed she was doing in that day where Joseph was at that critically low blood sugar level. What's your take, at least at this point, about the possibility of her testifying?
So I would speculate, and it's my opinion based on her demeanor in court, some of the stuff you just showed me in her constant communication with the media, with yourself. She wants to tell her story. She's dying to tell her story. However, if I'm her defense lawyer, I would sit down with her and go through a couple hours of cross-examination and discuss with how she's going to get cross-examined viciously about allegedly being asleep, allegedly not being able to move under the prescription drugs, but she's searching on the internet, she's ordering groceries, she's walking around, you know, up to 160 steps during that time period when her phone is not being used during those time periods. Just that small amount of information, you could cross-examine her for, you know, 30 to 45 minutes and make her look like potentially she's not being truthful to the jury. So as I told you before, once a defendant testifies, the whole focus of the trial changes. You could have done great work and you've made a lot of progress in reasonable doubt, but once the defendant testifies, if they believe she's not being truthful, there's a much stronger chance of being convicted. So I'm very curious to see what happens in this case. It's her decision. Her defense lawyer can't tell her to or to not testify. If I'm a betting person, I think there's a decent chance she's going to testify in this case.
We will have to see. I have seen, obviously, a lot of notes that have been taken down. I mean, it looked like a whole page today of things, it appeared. And so we'll have to see what ends up happening. I want to ask you, because, again, in that clip we saw where she leaned in and made the face and said something to the attorney, the prosecutor actually objected, I think, at least twice today, and said, you know, she was objecting to the sidebar comments from the defendant. Is that a, reasonable objection? The judge overruled, I will say, both times. But I'm just curious. Have you heard that or seen that come up before?
I've seen it before. So the prosecutor is basically trying to make sure that what she is saying, the jury can't hear. But on the other side, it's an admission by a defendant. It's a statement by a defendant. I mean, it just kind of depends on what the person's saying. In the moment, the circumstances surrounding it. But the prosecutor's just trying to make sure that the jury is not being influenced by anything she's saying. And it can also be a way for her to testify without actually testifying. So they kind of want to control that.
Yeah, no, that makes sense. She obviously, you can't really hear what she's saying. If someone's, I guess, good at reading lips, maybe they could figure it out. But I couldn't certainly tell what she was saying when she would reach over or lean over to him and say something. I think that really kind of wraps up all of the questions and things. I know it's been a couple days since we got to catch up, Rick. Is there anything that kind of stands out to you about where we are? Again, this was day 7. The state has not yet rested. Just kind of your final thoughts.
Well, I think the state has some momentum in this case in terms of the evidence that they put on today. I'm very curious to see, number one, obviously, if she testifies, and number two, what the defense outside of her testimony is going to attempt to put on to kind of stop some of that momentum. They have to have some type of medical expert to talk about their version of the case and what they think happened in this case. So I anticipate there's going to be some evidence by the defense. I'm just curious to see what it is.
Yeah, it will be interesting. I think that one of the witnesses that they subpoenaed actually is Joseph Hartsfield's ex-wife. I have never talked with her, so I think it'll be interesting to see if she does end up taking the stand in this. And so, Rick, thank you so much. Oh, by the way, there was one other question that I see about something about the drugs that were in his system in addition to the insulin. This has been from the medical testimony, but according to the prosecution, it was Benadryl, Valium, and something else called ropinirole, which I guess is a drug that is used to treat restless leg syndrome. Some of those obviously could cause drowsiness, according to the medical testimony that we have heard. And this person also asked if the prescription was in her name. I think according, yes, to the detective that we heard from today, that those prescription pills were prescribed to her. And also that, Joseph Hartsfield kind of had this aversion to taking any sort of medications. He really didn't like taking it. So that was something that we had heard in medical testimony last week. But Rick, one more thing, actually, because I just thought of this, too. Since we are at day 7, prosecution has not rested. We're told this could be about an up to a 3-week trial. I think this would maybe put us halfway through now. Timing-wise, what are you thinking?
Well, it's gone quicker than I expected. But so typically a judge will ask us, Mr. Duterte, Mr. and Mrs. Prosecutor, how long do you think this case is going to take? We tend to say longer than we think it will because we want to make sure that we don't upset the court. The court has to do things in terms of its docket and try to figure out what they're going to, how they can fit in the trial. So we tend to overestimate. When you get in trial, sometimes things change. Sometimes things go so good for the prosecution that you don't want to call all the witnesses that you expected. So it's very fluid. It's very difficult to predict, but it's going faster than I thought it would. Yes, sir.
Oh, okay. Well, we will obviously keep in touch and do some additional debriefs here on YouTube Live throughout the week, because I know there's a lot of people who are interested. And obviously, since it's not being live streamed, we're trying to keep the blog updated on Click to Houston throughout the day. And there's a lot that's happened. Like I said, dozens of witnesses have testified already. So, Rick, thank you so much. We'll check in with you again soon.
Yes, sir. Thank you. Have a good night.
And before we go, we did just want to leave you with some of the recap that we had right after court ended today, because, again, there was a lot of key testimony that came out about some of the phone records that the detective was able to recover when they did a download of Sarah Hartsfield's phone as they started investigating her for allegedly killing her 5th husband, Joseph, with insulin. We'll be back at the Chambers County Courthouse tomorrow for day 8 of this murder trial. Have a good night.
The lead investigator in the Sarah Hartsfield murder case says what she found in phone records does not match up with all the defendant's story.
The former Chambers County Sheriff's detective has been on the stand all day testifying about what she calls inconsistencies and what Hartsfield said about how her 5th husband died. KPRC 2 News reporter Bryce Newberry is live in Chambers County. Bryce, this is brand new evidence you saw in court today.
Yeah, Lisa and Keith, Sarah Hartsfield claimed to be on narcotics and sleeping for hours while her husband lay dying from this insulin overdose. But the lead detective testified today that her phone records contradict that. Instead, the detective says she was making calls, sending text messages, ordering groceries, looking at her Facebook and banking apps, and even using Joseph's phone to set herself up as his legacy contact, which is basically letting someone you know have access to all of your Apple data after you die. The detective, Skylar Rocks, was on the stand for most of the day today, getting grilled by the prosecution, only getting a few questions from the defense. By the end of the day, the detective said that Sarah Hartsfield gave several different versions of the story, and those versions did not match up. Joseph Hartsfield's glucose level was critically low for about 20 hours. The detective said more than 100 glucose monitor alarms went off. And the detective said her phone records revealed she was actually calling and texting, walking around. Apple Movement picked that up, and doing internet searches. In that time, when medical testimony has revealed that Joseph Hartsfield would have been pretty incoherent based on his very low sugar level, the detective said messages got sent from his phone to her phone, including a picture of his new bank account information and his driver's license. The detective said that they found records in the days leading up to Joseph Hartsfield's death about Sarah Hartsfield's internet searches, but in the day before and the day of his hospitalization, the internet search history had been deleted. The defense did point out, though, made sure that the jury was aware that several mistakes were made during the handling of this investigation because law enforcement never collected insulin pens from the couple's bedroom.
All right, and Bryce, we understand that the phone records also revealed information about life insurance.
Yeah, life insurance did come up during today's testimony. Initially, the detective said that Sarah Hartsfield gave a statement saying that she wasn't aware of any life insurance policies. But then, as the detective combed through all of those phone records, she found messages actually between Joe and Sarah months before his death where they actually discussed life insurance. In fact, in one of those texts, Sarah Hartsfield was ensuring that Joe had a beneficiary set up on his policy. She also said that she had a policy set up. Tonight, though, we do not know where, if any of that money went anywhere.